Hi, my name is Rachel Austin, and I'll be giving my presentation on New York state law pertaining to gender and sexual orientation. Today I'm going to be discussing several topics. I'll first discuss a brief history of gender and sexual orientation law in New York State, discuss current legal protections or lack thereof, and highlight some case examples where necessary. We'll also touch on areas of controversy in the expansion of legal protections for the LGBTQ community, and lastly, highlight some organizations and resources available to those interested in LGBTQ politics or in need of legal support in the New York area. I've included a quote from Harvey Milk, the first openly gay person elected to public office. This was in California, that I hope we can keep in mind as we discuss today's topics. Milk said, "It takes no compromise to give people their rights. It takes no money to respect the individual. It takes no political deal to give people freedom. It takes no survey to remove repression." We've all seen the scales of justice, sometimes held by a blindfolded lady of justice, and we all know the famous phrase, "justice is blind." This common adage is meant to say that no matter who you are, everyone is equal in the eyes of the law. We know that this is the ideal, but has justice historically been blind? Have the scales ever been level? And are they level now? Will they be in the future? These are basic questions we must constantly ask ourselves as a society, both global and domestic. Our basic sense of humanity, or lack thereof, is reflected in our law, and though law is slow to change, it does in fact change. So today we'll focus on New York State and review how the law has changed and continues to do so within that purview. We can't know where we're going without knowing where we've been, so let's discuss a brief history of LGBTQ issues in New York. New York City, and more specifically Greenwich Village, is where the famous Stonewall Inn is located. This gay bar, which was commonly raided and whose LGBTQ patrons were unfairly targeted by police, albeit backed by discriminatory laws at the time, is famous for what we now call the Stonewall Uprising. During the 60s, this nightclub located in New York City was a haven and a common hangout for the LGBTQ community. However, they faced police repression, and innocent folks were arrested or beaten for expressing what we now consider to be normal variations of gender and sexual orientation. In June 1969, police raided the club, but this night the crowd had had enough and they fought back. Several days of demonstrations resulted following the nightclub riot, and a movement that had largely existed in the shadows came into the light. While there were surely LGBTQ activists before the state, the Stonewall Uprising is largely considered to be a significant milestone and a spark for intensified movement activity. In June of this year, President Obama named the Stonewall Inn an historic landmark under the National Park Service, offering deference and legitimacy to a movement once considered to be inherently deviant and lacking in moral character. Obama stated, "The quest for LGBTQ equality after Stonewall evolved from protests and small gatherings into a nationwide movement. Lesbian women, gay men, bisexual, and transgender people united to ensure equal rights for all people, regardless of their sexual orientation or gender identity." Hard-fought civil rights victories in courtrooms and state houses across the country set the stage for victories in the Supreme Court that would have seemed unthinkable to those who rose up in Greenwich Village in June 1969. In looking at just this example, we can see that in some ways we've come quite far. Prior to this time, however, in some cases up until quite recently, much of New York law affecting the LGBTQ community was similarly draconian as the repressive efforts exerted upon the Stonewall Inn patrons. Laws that have existed in New York that have systematically oppressed the LGBTQ community through sodomy laws, lack of public accommodation, such as the ability to be served liquor or to congregate, and lack of civil rights, such as the ability to marry someone of the same gender, as well as laws that allowed brutal treatment of LGBTQ folks within a psychiatric setting through lobotomy and sterilization. Anti-sodomy laws were instituted during early American settlement in New York and was at times punishable by death. Sodomy was illegal in New York from 1600 through 1980. From 1912 to 1920, it was also legal in New York to punish the quote, criminally insane and to prevent the birth of quote unquote, undesirable children through forced lobotomy and sterilization. We also call this eugenics. In later time periods, such as the 1900s through 1970, vague and sometimes ambiguous laws were used as tools of oppression towards the LGBTQ community. Such laws prohibited, quote, lewd behavior or, quote, congregation of homosexuals, and were the legal basis for many of the raids on the LGBTQ community and gathering places such as the Stonewall Inn. Let's take a look at a few specific cases from New York, some good and some bad. In the People versus Onofre, the 5 to 2 majority opinion in the New York Court of Appeals decriminalized sodomy in 1980. The case involved a man charged with sodomy for consensual sex with another man who appealed his case to the state level and won. Citing earlier cases in Connecticut and Georgia, the decision stated, quote, "It is not the function of the penal law to provide for the enforcement of moral or theological values," and, quote, "The fact remains that Western man has never been free to pursue his own choice of sexual gratification without fear of state interference. Consequently, it simply cannot be said that such freedom is an integral part of our concept of ordered liberty as embodied in the due process clauses of the Fifth Amendment and 14th Amendment." Almost 20 years earlier, in the matter of Anonymous versus Weiner, however, a transgender person who wished to change their name and gender on their birth certificate had no such success in the courts, and the decision dictated that changes can only be made in the event of clerical error. Thus, the status quo was upheld. Let's now turn to the current legislative landscape. New York currently has legislation on the books that pertain to these major areas of life: the home, including housing, landlord and lending practices, public accommodations, including business and public access, work and school, and hate crime legislation. First, let's consider legislation pertaining to the home. Relevant statutes under New York State human rights law are listed in blue, and these are specifically defined in the resources cited at the end of this presentation if you wish to read them in entirety. Fair housing law in New York under the Fair Housing Act and New York human rights law makes it illegal for housing providers, owners, managing agents, superintendents, and real estate agents to discriminate on the basis of sexual orientation, and also legally prohibits discrimination on these grounds in lending practices and in cooperatives and community boards. It is important to note that gender identity is not covered under the Fair Housing Act. However, some local governments have included this criterion as well. SONDA stands for the Sexual Orientation Non-Discrimination Act, effective in New York as of 2003, which prohibits discrimination based on sexual orientation in housing, among a number of other areas. Government at the local level have passed similar legislation with regard to gender identity, but this is not uniformly the case in the entire state of New York. About 20 different cities or counties have adopted anti-discrimination legislation regarding gender identity, including Albany, Buffalo, Ithaca, New York City, Rochester, and Nassau County. In the realm of family, New York State legalized gay marriage in 2011 with all the typical rights, benefits, and privileges of marriage, and similar federal law was subsequently passed in 2015 with the Supreme Court's landmark decision. Let's next consider public accommodations. New York State human rights law prohibits discrimination on the basis of sex or sexual orientation. It is important to note that this does not include gender identity. However, some local New York governments have expanded this law to include gender identity or expression. These New York cities or counties are listed before you. Public accommodations include access to such places or organizations as shown in the green part of this slide, and as you can see, it encompasses access to a laundry list of business and public resources. Next, let's consider human rights law as it pertains to the realm of education. Federal law under Title IX prohibits harassment or discrimination on the basis of sex or gender identity in educational institutions, and it covers all realms of educational institutions like student housing, work study programs, classroom conduct, student activities. Equal education legislation under New York human rights law makes it illegal for non sectarian institutions to discriminate on the basis of sex or sexual orientation. Something important to note here is the term non sectarian, which means that religious institutions can legally discriminate on this basis. Equal education legislation also does not cover gender identity, but SONDA, which we introduced when discussing the home, also prohibits discrimination in education on the basis of sex or sexual orientation. Again, this protection does not include gender identity, but transgender persons may be covered if they're discriminated against on the basis of perceived sexual orientation. Lastly, DASA, which stands for the Dignity for All Students Act, provides legal protections in New York State against school bullying, including discrimination, taunts, threats, aggressive conduct, harassment, and cyberbullying. In the workplace, New York State human rights law protects some groups against discrimination in the workplace and employment. Notably, one cannot be discriminated against on the basis of sex or sexual orientation, but again, this does not include gender identity. Discrimination is prohibited in the practice of former employers providing work references, in job advertisements, and in union membership. When advertising for a job, employers can't exclude a protected group of applicants unless the status is inherent or central to the job at hand. For instance, if a TV producer is casting for a male actor only because they need to fill a male role, that would not qualify as discrimination. Further, one cannot be excluded or dismissed from union membership on the basis of sex or sexual orientation. In relatively new legislation passed in New York, the use of gendered pronouns has been regulated. Here you can see some examples of gendered and non-gendered pronouns, which are to be used when referring to any given person in accordance with their preferences based on their own gender identity. This law pertains only to New York City, not the state at large, but issues fines to employers, landlords, or business owners who fail to use someone's preferred name, pronoun, or title. It's important to note that accidental verbal slips don't rise to the level required to be fined, but this is meant to provide legal protection for people who experience intentional and repeated misuse of gender pronouns as a way of verbally disrespecting or publicly outing an individual. Further, the New York City Public Accommodations Law can give fines for enforcing gender segregation on the basis of biological versus gender identity. Enforcing gendered appearance standards such as dress or grooming is also illegal, and denying benefits and reasonable accommodations for individuals undergoing gender confirmation treatment is also illegal. Upon announcing these progressive new laws, New York City's Human Rights Commissioner Carmelyn P. Malalas stated, New York City does not and will not tolerate discrimination on the basis of gender identity or gender expression. Every New Yorker deserves to live freely and safely, free from discrimination. It can also cost you to violate any of these regulations. Civil fines for violating these laws of public accommodation in New York City can be up to $125,000 for violations, up to $250,000 for violations with malicious intent, and can result in compensatory damages ordered to an unlimited amount of money. That's to say, there is no cap on damages that may be ordered. The last category we'll consider is hate crime legislation. Hate crimes are defined as crimes that target individuals due to their membership in a group in an attempt to intimidate one on the basis of this membership, such as targeting a victim based on race or disability status. The victim's group membership can be either real or perceived, so the person does not have to actually belong to the group for a hate crime to be committed. The perpetrator can still be charged with a hate crime if they wrongly perceived the victim to be part of the group. Hate crime legislation in New York State offers additional criminal charges and stiffer penalties for crimes of this sort. New York State hate crime legislation includes sexual orientation but does not cover gender identity. However, federal legislation, more specifically the Matthew Shepard and James R. Byrd Hate Crime Prevention Act, expanded protections to cover gender identity, and this can be applied in New York. This legislation also legally mandates that hate crime data are collected and reported for the state. Let's look at some figures to see if we can get a snapshot of what hate crimes look like in New York City, or I'm sorry, New York State. The first figure you see is the percentage of hate crimes committed in New York State in 2014 that targeted gay men. This is the most targeted group. The second figure is the percentage of hate crimes committed in New York in 2014 that targeted any sexual orientation minority. The third figure shows the percentage of targeted victims for their gender expression, and the final number shows the percentage of hate crimes in New York 2014 that targeted someone for being transgender. Here I think it's important to stress that the last figure shows one victim, but even one victim is too many. Further, we know that hate crimes are often underreported, so these numbers are likely lower than they truly are. Of course, none of these issues are without controversy. Criticisms of more recent LGBTQ legislation typically come in these forms, particularly in the case of the newer policies of New York City regarding gendered pronouns, criticisms of infringing on freedoms of speech, government overreach, quote, reverse discrimination, and a society overly concerned with political correctness have been argued by those wishing to maintain the status quo. To these, I have offered some rebuttals in purple text. As to the first point of infringement on freedom of speech, I would reaffirm that freedom of speech does have limits and does not include the ability to discriminate against people. As to the accusation of government overreach, I would argue that participation in civil society comes with expectations to conform to our larger cultural norms of fairness and justice, and the government has a unique ability and responsibility to do so. As to the charges of reverse discrimination, I would contend that this is simply a way to offer coded support for the status quo. Human rights are not zero sum. If rights are given to a group you don't belong to, that doesn't mean that yours have been diminished. Further, nearly any data you find can clearly show that reverse discrimination does not actually operate on any institutional level anywhere. This is a common charge by those who wish to maintain unearned privilege, but it is less a social reality than a paranoid figment of imagination. Lastly, to the point that we are too concerned as a society with being politically correct, I would reaffirm what the federal government has stated with regard to HB2. In short, they said just because you think it's inconvenient to change the way you do something doesn't mean that systematic discrimination against an identifiable group of people will be tolerated just to make your life easier. Now, let's take a look at some other legislative controversies that are currently at hand. The first deals with ENDA, which is a federal bill, so it's not specific only to New York, but it has been an issue for many New York based advocacy groups that have been involved in this controversy. ENDA stands for the Employment Non-Discrimination Act, which has been introduced to every Congress, save for one, since 1994, but still hasn't been passed into law. This act would make it illegal to discriminate against people on the basis of gender identity or sexual orientation in employment and hiring. On its face, that sounds great, and traditionally most LGBTQ rights organizations have been behind it, but the outcome of the Hobby Lobby case, if you recall, this allowed Hobby Lobby to deny medical coverage for birth control on a religious basis, has called this into question, and recently some heavy hitters in the LGBTQ camp are now coming out against it. A joint statement issued by advocacy groups Lambda Legal, the National Center for Lesbian Rights, and the American Civil Liberties Union states, quote, ENDA's discriminatory provision, unprecedented in federal laws prohibiting employment discrimination, could provide religiously affiliated organizations, including hospitals, nursing homes, and universities, a blank check to engage in workplace discrimination against LGBT people. Let's have a listen to an interview on NPR that can shed some light on this. I've included a transcript on the slide so you can follow along.
Now to another striking outcome of the Hobby Lobby ruling. This week, multiple gay rights groups announced that they are withdrawing support for legislation they have championed for decades. The legislation is known as ENDA, the Employment Non-Discrimination Act. Gay rights groups had been pushing for the legislation that would extend current non discrimination law to protect workers based on sexual orientation or gender identity. Now, the same groups say the Supreme Court's ruling would give private companies too much leeway to discriminate against LGBT people. Ray Carey is executive director of the National Gay and Lesbian Task Force, and she joins me here in the studio. Thanks for coming in.
Thank you.
This does seem counterintuitive that your group and other groups are withdrawing support for a non-discrimination bill that's intended to protect LGBT people. And your concern, as I understand it, has to do with a religious exemption within that bill. What's the concern?
The National Gay and Lesbian Task Force has now come out and opposed the Employment Non-Discrimination Act because the political landscape has changed. We and other organizations have had concerns about the religious exemption included in ENDA all along. What started happening, though, is that we were able to see, both in states like Arizona and Mississippi, where a religious exemption law passed, and then in the Hobby Lobby case, how religious exemptions were being used to discriminate against people.
And your fear in the case of ENDA is what specifically? Because again, this is legislation you've supported for many, many years.
Our fear is this. Unlike other civil rights legislation, the religious exemption that is written into the current version of ENDA legalizes discrimination against LGBT people and LGBT people only. So, for example, the language of the religious exemption in ENDA is much broader than that of Title VII of the Civil Rights Act of 1964, for example. Under current civil rights law, in Title VII, a religious institution is free to hire people of the same faith for religious positions. So a Catholic hospital can hire a Catholic priest for that hospital. They don't have to hire, for example, a rabbi. What happens with the language in ENDA is that that same hospital could choose not to hire or fire a cafeteria worker, a janitor, a receptionist, simply because they are gay, lesbian, bisexual, or transgender.
This language was included in the bill that you supported. This religious exemption was there. Was it a case of you and your and other gay rights groups making the calculation that, look, we don't like this, but if that language is in there to get the bill passed, we'll live with it?
For many years, our calculation was we need to try to get any protections we can for LGBT people. And honestly, when the bill was introduced in 1994, if we had had this particular religious exemption, we probably would have celebrated the bill's passage. But that was 1994. There were zero protections for LGBT people federally. There were only 9 states that protected against discrimination, only one of which protected against discrimination with gender identity. What's happened in recent years is that we have made progress as a country when it comes to treating LGBT people and same-sex couples fairly. So the landscape has changed. We have progressed,
Another
and so should the
controversy
bill.
has been over a quote anti-gay cure bill that was specific to New York but has been similarly considered in other states, most notably in effect in California. The legislation would have made conversion therapy for youths illegal. In 2014, the New York Senate blocked the bill from passing to the dismay of many. This is out of line with what the psychological community has advocated for. The APA has stated that conversion therapy is not a proven method to change sexual orientation, nor is sexual orientation something that should be changed. Same gender or bisexual orientation is considered a normal and healthy variant of human sexuality, according to the APA, and further, conversion therapy can be psychologically damaging, especially to youth. Despite these warnings from the psychological community, the law has not conformed to these contentions. Now that we've had an overview of LGBT law in New York, I want to pivot at this point to answer the question of what can we do now? What is being done in the state of New York? But first, some food for thought. This slide includes a bit of comic relief, but it gets at an important point. James Howe says, quote, "Another thing I'm sick of hearing. If I started a gay rights group, I must be gay. So if I start an animal rights group, what does that make me? A giraffe?" Those of us in the majority tend to think of issues such as these as only pertaining to certain people, but when anyone's rights are denied, the entire human race suffers. Further, the apprehension of the privilege to stand along with and advocate for those who are oppressed passively reinforces marginalization of that oppressed group by maintaining a gulf between straight and cisgender persons and the LGBTQ community. Through advocacy, law, community, and cultural shifts, we have come so far, but still have so far to go. And as we have seen, change does occur, but we must be willing to work together. So, what organizations and resources exist to advance legal protections for the LGBTQ community? There are a number of organizations in New York that work in advocacy, provide pro bono legal services, are involved in movement organization and mobilization efforts, lobby on behalf of LGBTQ rights, and offer support and resources to the community. Several organizations were established during the years shortly following the Stonewall uprisings um, to help combat legal discrimination against the LGBTQ community, and many of those New York based organizations still exist today. Lambda Legal is one of the oldest organizations established in 1971. This is a nonprofit organization offering free legal services and advocacy to LGBTQ persons. They advocate at the public policy level and litigate cases for LGBTQ folks related to family law, immigration, employment, housing, and they take an interest in teen, elder, and the Latino community. Their focus on intersectionality and multiple levels of oppression is impressive and needed. The National Gay and Lesbian Task Force was established in 1973 and initiates grassroots efforts to mobilize support for LGBTQ rights. This organization focuses on social justice and organizes a number of community awareness events. Lastly, ACT UP, which stands for the AIDS Coalition to Unleash Power, brings a necessary level of contentious cultural politics to capture the public eye on behalf of legal issues in the LGBTQ community. ACT UP initially formed to respond to government apathy during the initial years of the AIDS crisis. The photo you see on this slide is a quote unquote die in, which is the type of theatrical protest events that ACT UP is famous for. These sort of moral shocks, as sociologists call them, are used both to challenge the status quo, empower the community to take a stand and express discontent, and to draw media focus to such critical public issues. As a final thought, I'd like to quote Supreme Court Justice Anthony Kennedy, who read the majority opinion in ruling gay marriage legal at the federal level, stating, quote, "They ask for equal dignity in the eyes of the law. The Constitution grants them that right." At the heart of these issues is a simple question of human decency and respect for others. It's a basic moral imperative that we must continue to evaluate whether or not our laws are aligned with the constitutional assertion that we are all equal under the law, and call our laws into question when they're not. This is a cornerstone of our nation, and we have a responsibility to ourselves as a human race and future generations to ensure that all are afforded equal treatment and human rights. I appreciate you taking the time to listen to this presentation, and I hope that you've come away with a bit more knowledge than you had at the beginning. If you wish to learn more about anything mentioned in this presentation, please explore the references listed in the next few slides. Image URLs are listed as well. Thank you so much.